Welcome back, everyone, to another episode of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I'm the founder and CEO of SERMA, Rich Lenkov. I'm also the host of the SERMAPod. We are nearing our 100th episode. Stay tuned for a special edition of the SERMAPod, but we're very fortunate today to have a very special guest discussing what really is a landmark piece of litigation that is at the beginning, not the end of the story of the NIL litigation. Very interesting discussion. We are fortunate to have Professor Matt Mitten. He's the executive director of Marquette's National Sports Law Institute. He is a professor of law there as well. He is a renowned expert in college sports law. He has covered this issue and many of the biggest sports law issues out there. He has 30 plus years of experience studying college sports law, spanning NCAA eligibility, antitrust, NIL, Title IX, doping policies, among many other areas. He is also an author of many textbooks, including Sports Law in the United States, Sports Law and Regulation, and Sports Law, Governance and Regulation. These are staples in the field. Again, we're very fortunate to have a professor. Thanks for joining us.
Well, my pleasure, Rich, and thanks for that kind introduction.
So this is a lawsuit involving the University of Wisconsin and the University of Miami. The allegation basically is that one school tampered with the other, involving a transfer of a very highly rated player that it's alleged that they violated some rules and the spirit of NIL. Give us a bit of a background about what brought us to this lawsuit, and then talk about the lawsuit if you can.
Well, it's based, in legal terms, it's a tortious interference with contract suit. So as I haven't reviewed the complaint or seen the relevant documents, but I think I know enough about to comment on it. So the player, I believe, was Xavier Lucas, and had an excellent freshman year as a defensive back at the University of Wisconsin. And then the Wisconsin and the athlete entered into an NIL rights deal. Of course, everyone was anticipating that Judge Wilkin would approve the House settlement, which she did. So what's significant about that is, for the first time, Division I schools that opt in, like Wisconsin did and Miami also did, they can engage in revenue sharing with their athletes, and that's what this NIL contract was. And it was going to be, as I understand, it was going to be a 2-year deal that was going to become effective July 1 of this year. And apparently Mr. Lucas went home to Miami for Christmas break, and the University of Miami apparently offered him a better deal. And he decided to accept that and transfer to the university. So Wisconsin is claiming, well, we had a valid contract, still valid, even though it wasn't going to go into effect till July of this year, and that Miami tortiously interfered with that by offering a better deal. This is a tort that recognizes the sanctity of contracts. It's been around a very long time. This is just, a rather novel application of it.
So players are free to enter the transfer portal and transfer from one school to another school. Why is that not what is going on here? What's the allegation that this transfer violates that process?
Well, he had entered into as part of this revenue sharing agreement, there would either be an express or at least an implicit provision that he would actually play football for the University of Wisconsin. So, but for that agreement that he had, revenue sharing agreement, I prefer to call it that rather than NIL, there wouldn't be a valid legal claim that Wisconsin would have. So let's take a different situation. This might make it a little bit easier for people to understand it. So let's assume after his first year, University of Wisconsin said, "Hey, you're quite a good player. We'd like to have you, play for us the next couple years. And they offered him, a deal. And he said, well, let me think it over. And then let's say the University of Miami said, hey, we're going to offer you a better deal. You could play closer to home. And he chose to enter into a agreement with Miami. That wouldn't be any problem. That would be perfectly legal. The key distinction here is once he actually signed that written agreement, that basically, arguably overrides his right to transfer. Because what he did is he decided to stay at the University of Wisconsin for whatever the period of that agreement was. I heard it was 2 years by entering into it.
So it's important to note, and to your point, Wisconsin is not suing the player themselves. They are suing the University of Miami for what they allege is tampering. So, to your point, any player is free to transfer. But in this case, it's, as you say, a very specific and rather simple question, whether he had to abide by the contract he signed with one school or whether he should be allowed to pursue the NIL deal with the second school. And I think the greater point is, to what extent did the University of Miami influence that decision? To what extent did they tamper? And if they did, then so what? The allegation is that's tortious interference, but talk to us about the merits of that. I mean, why can't Miami do what they are alleged to do here?
Well, I think what the University of Wisconsin wants to do is, this would be a precedent-setting case. They want a judicial decision by a Wisconsin court, because they filed suit in Wisconsin, that would basically say, hey, when a student athlete enters into an agreement like this, they have to honor it. And as you pointed out, the athlete is not a party to the lawsuit. So Wisconsin is not suing Mr. Lucas for breach of contract. And the typical remedy for breaching contract would be money damages. In cases of personal services contracts like this, where you have, entertainers or athletes with unique special skills, courts have in the past granted injunctive relief to the party that basically would prohibit an athlete from playing for someone else during the contractually agreed period. Courts would not order the athlete to perform that contract by, for example, here playing for the University of Wisconsin. We do have the 13th Amendment, which prohibits involuntary servitude, and courts wouldn't want to try to supervise that. You might imagine the athlete wouldn't be too happy. There could be some conflicts back and forth. So that's not an available remedy. And the University of Wisconsin is not seeking to prevent Miami from permitting Mr. Lucas to be on his football team. So they want to establish what would be a very important precedent that says, hey, once a school and the athlete have entered into an NIL rights deal, it is a valid contract. So what remedies could they get? Well, they could get some damages. And because this is an intentional tort, punitive damages would be possible. So punitive damages are designed to punish and deter, to send a message that, don't interfere with a valid and existing contract.
So, Professor, one of the interesting, and like you said, it's a watershed case, one of the interesting dynamics at play here is the conflict between the contract, the NIL deal between Wisconsin and their athletes, which explicitly state that you can't play for another school while you're getting NIL money from Wisconsin. That's on one part of it. That conflicts with Big Ten contracts, which state, or Big Ten rules perhaps, that state that you can't pay a player to play for the school. You can't pay a player to play for the school, right? You're paying that player NIL money. That's different than paying a player to exclusively play for Wisconsin. Those two concepts seem to be a conflict here. How do you think the judge is going to remedy that?
Well, I'm not sure I really see a conflict because, after July 1st, this, the House settlement, these NIL rights deals between a university and its athletes, that's effectively pay for play. And the way it's structured is each Division I school can each year enter into the first year. This year, I think it's $20.5 million. Each school retains their own discretion as to how they're going to parcel that money out. Are they going to spend the full amount? A lot of schools are, if they can afford to do it. How much, in the athletes in the revenue generating sports, football and men's basketball, that's where it looks like the bulk of the money is going to go to. So that is permissible. The NCAA member schools, going back to their founding in 1905, had agreed that one of the things that would distinguish college sports from professional sports would be that athletes are not paid to play. But these effectively are, even though they're characterizing it as NIL deals. It's you're not going to get. So for example, University of Wisconsin is not going to be paying Mr. Lucas anything because he would not be playing for them. So I think it's really a pay for play agreement. And of course, there'll be some use of the university by, of his name, image, and likeness, like in promoting the team, for example. The legal theory was college athletes were claiming that, the fact that they're shown in the broadcast, that's effectively use of their name, image, and likeness. Therefore, they're entitled to compensation for it. But if we distinguish this from, let's say, an athlete enters into a deal with, let's say, the local car dealership to show up, sign autographs, appear in commercials, that's a true pay for publicity deal, where the auto dealership is hoping that it will sell more cars by having a particular, university athlete, being a product endorser.
Professor, this case has to be viewed in the light or in conjunction with the House settlement and also with other high-profile athletes who have transferred this offseason. Nico Emabalea transferred from Tennessee, where he had a very successful career there. He walked away from $2.4 million in NIL money to go to UCLA, and two other brothers, or his brother, left as well. I think there were buyout clauses there that compensated the schools from which they left. Do you think, in light of the lawsuit and that we're discussing today, you'll see more of these buyouts where the schools that are that the transfer players are coming from are going to get compensated in some way? It would seem logical that you would put that kind of language in the contract, given all these transfers.
Yeah, I think, because again, it's back to the idea of it's up to the athlete. Who do they want to play the particular sport for? And right now they can transfer, you could conceivably play for 4 or 5 schools. The rule is still 4 years of eligibility to play the sport within a 5-year period. So the athletes can choose initially who they play for, and if they decide they want to go somewhere else. But the key point is, once they enter into an agreement to play for a particular school for a particular period of time, there's going to be consequences legally if they choose not to do so. And one of it could be schools might put in and say, well, if you're going to go on somewhere else, we're making a commitment to you. You're a good player. And if we lose you, we're going to have to try to find someone comparable. You are going to have to pay what's typically known as a buyout or liquidated damages. Fairly common, you see that in college coaches' contracts, where they will, enter into a multi-year deal. And if someone's like a rising star, the school wants to protect its investment in it. But the coach, they typically let them go somewhere else, maybe a more prestigious school or for more money. But then they say, well, wait a minute, it's typically the school that the coach is going to pays the buyout. And it's interesting that is contemplated in this new system that we have. So as part of the 20.5 million that Division I schools can allocate. So let's say an athlete enters into a 2-year NIL rights deal, and after 1 year wants to leave to go somewhere else. And let's say there's a $500,000 buyout, which typically the new school would pay. That gets subtracted from the 20.5 million. So what the objective here is to establish kind of an orderly system where it's like student athletes have a greater degree of choice than major league professional athletes have, where you have collectively bargained drafts, free agency restrictions that we don't have with college sports. But it's back to the idea of once you sign on the dotted line, once you agree to something, that there's rights and obligations that both the school and the athlete have, and certain legal consequences if one or both, don't want to perform their agreed obligations.
Last question. How do you think the case resolves? Do you think the parties are going to settle it, or do you think this is possibly a precedential setting case if it goes to trial?
Well, I think the reason the University of Wisconsin brought the suit is they want to establish a precedent, and they've gotten pretty strong backing from the Big Ten. And I think, quite honestly, there needs to be a precedent, because it would establish, much needed order in the system. One of the interesting issues is going to be, is it going to be a Wisconsin court that's going to decide this case, or perhaps a Florida court? So you would expect the University of Miami to probably do one or both things. Try to get the case removed to federal district court. Some would think that, often defendants, Wisconsin's got elected judges, and, out of state defendants might feel, well, that's providing an unfair home field advantage, so to speak. And if they can get the case removed to federal court, federal judges, of course, are appointed by the president with consent of the Senate and have lifetime tenure. Some would say, well, they're not as subject to local political influences. The other thing that Miami might try to do is get the case transferred to a Florida court. They would argue that, well, to the extent that we're being accused of tampering with this agreement between Wisconsin and Mr. Lucas, it's best resolved by a Florida court, because that's where the alleged tortious conduct occurred. Wisconsin will argue, wait a minute, we're seeking to have a court enforce a contract that was entered into in Wisconsin. That's where, Wisconsin and Mr. Lucas executed the deal. So that'll be an important threshold question. But it's difficult to see, what type of a settlement would, both parties would be interested in, because it's pretty clear Wisconsin wants to establish the precedent, probably more so than getting damages. They're not trying to prevent Mr. Lucas from playing for Miami. So, I think that's really what they're interested in. And I think the case will probably be decided by a judge. And the question is going to be, is it a Wisconsin state court or federal court judge, or perhaps a Florida judge?
We'll be watching for sure. National Sports Law Institute Executive Director, Professor Matt Mitten, thank you so much for joining us on the SERMAPod. Please come back.
Pleasure. Always good talking to you, Rich.